All right. Are you ready? Chapters 1 and 2, I'm going to lump those together. 11 questions. Among the sources of law, the thing we studied the very first day, remember that the supreme law of the United States is the United States Constitution. We talked about different branches of governments and their duties and their abilities. And we talked about the checks and balances and said that some branches can do something to other branches. They have a way of checking and balancing it. In the case of the President of the United States and some governors of the states, they have the power, as part of the executive branch, for instance, to veto actions of the legislative branch. So when you hear the term veto, that means an executive branch over the legislative branch. At the beginning of a trial in a civil or a criminal case, of course, a jury is chosen when there's a jury trial involved. And the process of questioning those jurors is called the voir dire, V-O-I-R-D-I-R-E. At trial, we have the questioning of witnesses. Remember that when the plaintiff puts their witness up on the stand, they have what we call direct examination of their witnesses, and then they allow the defense side, or however many defendants there are, cross-examine the witness. So it's direct examination by the plaintiff of their own witnesses, cross-examination by the defense of the plaintiff's witnesses. And then they switch roles. When we talk about the decisions that appellate courts make, they normally look at the lower court ruling and they have the ability to do one of 3 or 4 things with the lower court ruling. One of the things they can do is they can affirm it, which means that basically they agree with the lower court. They can also reverse it, which means they disagree, and in some cases they can reverse it and remand it, R-E-M-A-N-D, which means send it back for a new trial. So if they reverse, say, a summary judgment that was granted, they may decide that the case needs to be tried, so they'll reverse it and remand it for a new trial. They can also modify it, but that's not one of the answers. Remember in our Jill Kirby and Antonio Carvello, or Anthony Carvello case, we had the various pleadings and the things that were done. And the first pleading that was done was by Jill and her attorney, who filed a complaint along with the court summons. And remember, both of those pictures were in the book of the actual complaint. So her first document, or the document that the plaintiff files, which sets out the grounds for the court's jurisdiction, the cause of action, or, in this case, what happened. There was a car wreck and Antonio was negligent, and the relief or remedy which Jill is asking for, which she seeks. When we talked about picking the jury in the voir dire, there were different types of challenges that lawyers can make to the jurors. One is a challenge for cause, which must show that somehow that juror will not be able to try the case and hear the case and deliberate without some kind of bias, or maybe pretrial publicity is going to change how they think about it, or they might be related to one of the parties in the case. And the judge has to rule on whether that's a valid challenge or not. But that type of challenge is unlimited. But there's also what are called peremptory jury challenges, and they are limited in number, and if an attorney cannot discriminate based on race or gender. Attorney's fees can come in different forms: fixed fees, or hourly rates, and what we call contingent fees. Fixed fee means a flat fee. You quote an amount, and that's what you normally get for whatever you do. Hourly is when you charge by the hour. And contingent is where you charge a percentage of the amount that you recover in the case. You may settle the case, or you may try the case and win it, and you get a percentage of that. The burden of proof in a civil case and the burden of proof in a criminal case. You need to know both of those. Remember that U.S. Supreme Court justices and all federal judges are served during good behavior, is what it actually says in the United States Constitution. We all say for life, but that's technically not correct. They serve during good behavior. And you can spell behavior either way, I don't care, but, basically, you'll pick it in the book. Chapter 4, 6 questions, one of which is actually from Chapter 1, but it has to do with the schools of ethical thought. Anyway, ethical dilemma faced by corporations is how do you serve the parties that you work for? If you're on the, say, the board or you're part of the management, you've got to figure out some way to satisfy the shareholders, satisfy the board, satisfy the officers, satisfy the employees, the vendors, and even the consumers or clients that you sell products or services to. So it's more or less kind of an all of the above, or you'll get to pick which ones apply and which ones don't. Another question from Chapter 1 again, but it has to do with those schools of thought. Remember, we have the different schools of thought, the natural law school, the positivist. Remember that what the positivist is that particular school said there's no such thing as natural rights, and whether a law is good or bad is irrelevant. You just have to obey the law, whatever it may be. Suppose that a company says to its employees that you need to apply the categorical imperative. Well, you need to know what the categorical imperative is. You need to know what utilitarianism is, and be prepared to contrast those with the golden rule. Okay? I'm not going to repeat them to you because they're kind of long and drawn out. At least you could shorten utilitarianism, though, the greatest good for the greatest number, so it's fairly easy to remember. But categorical imperative is a little more wordy. Questions of corporate social responsibility involve the extent to which a corporation, or any business for that matter, has ethical duties beyond those mandated by law. Remember, the law is an ethical minimum, and just because something is legal doesn't mean it's also ethical. Chapters 5 and little parts of 7, remember we took memorandum and exclusionary rules, stuff like that from chapter 7. 7 questions. The written document adopted by the Constitutional Convention of 1787 became known as the United States Constitution. The Bill of Rights, which we know as the first 10 amendments to the United States Constitution, generally to protect us from the federal government. In the case of Katzenbach versus McClung, not in the book, but similar to the Heart of Atlanta case, which is mentioned in the book, involved the Mr. McClung, who was the owner of Ollie's Barbecue, who refused to integrate his barbecue place in Birmingham, Alabama, because he said he was not engaged in interstate commerce. He was engaged in intrastate commerce, and the Supreme Court ruled, and I think the trial court might have ruled too, but I know the Supreme Court ruled that he was engaged in interstate commerce, whether he knew he was or not, because he had materials and supplies and food which were brought in for his restaurant from out of state. Therefore, he was engaged in interstate commerce. In this particular question in the exam, there are two answers that are identical except for one word. And that one word is interstate in one of them and intrastate in the other. The answer, of course, is he was engaged in interstate commerce. Freedom of speech, as we know, doesn't protect everything. We've had this question before. Sometimes I word it one way about what it protects the least or what it protects the most. One of the things it does not protect is defamation. You can't defame somebody and then claim freedom of speech. According to legal scholars, of all the clauses in the United States Constitution and its amendments, the one that is the most important is the Commerce Clause. And we learned that, even though that was something you don't always know about. One of the exceptions to the requirement that the government, police, investigative agencies, whoever it may be, must first obtain a warrant before conducting a search and seizure is the plain view exception. Plain view means that if they look in your car and can see in through the windows that you have an open container, concealed weapon, or a marijuana roach in the ashtray, that's in plain view, and that gives them grounds to search your car. The same is true with a house. If they happen to be able to see in and see something going on inside that's illegal, then they don't need a warrant to go in your house. According to the exclusionary rule, evidence obtained illegally by the government cannot be introduced or used in criminal trials.